Ever get that nagging feeling that maybe someone's looking where they shouldn't?
Mm-hmm.
Or maybe you've tried following a legal case and just wondered, how did they get that piece of evidence?
Yeah, it can seem pretty opaque sometimes.
You're definitely not alone. So today, we're taking a fascinating plunge into Brazilian law.
Right. Using that great material you shared from the STJ, the Superior Tribunal de Justiça.
Exactly. And our focus, it's trying to untangle this really crucial difference between how investigators gather information, specifically fishing expeditions versus what they call serendipitous findings.
It's all about figuring out what's legal and what crosses the line, where that boundary is.
Yeah, drawing that line in the legal sand.
Absolutely. And these STJ rulings, they give us a fantastic way to look at this. Our goal today, really, is to dissect these concepts for everyone listening.
Pinpoint where that legal boundary lies.
Exactly. Make it clear what separates a lawful investigation from one that, maybe oversteps and could impact fundamental rights.
And we'll use the specific cases from your sources, right, to make it concrete.
Definitely.
Yeah.
By digging into those specific examples, we can get a much sharper picture of how the STJ is handling these, let's face it, tricky situations and what it means for people.
Okay, so let's start with the forbidden one, this idea of a fishing expedition, or pescaria probatoria in Portuguese.
Right.
Now, based on what you shared, this is a definite no-go in Brazilian law.
A major no-go. It's prohibited.
So it's basically when investigators go on a kind of speculative hunt, looking for evidence without a specific target, not really sure what they're after, just hoping something turns up.
That's a good way to put it. Just casting a wide net, hoping to catch something incriminating. It's not about looking under every rock just in case. It has to be more targeted than that to be legal.
Right.
And that definition from Alexandre Moraes da Rosa, which Minister Rogério Cedi Cruz highlighted in one of the cases, HC 663.055, really nails it.
What does it say?
It calls it a speculative search, without probable cause, defined target, tangible purpose, or beyond authorized limits, of elements capable of attributing criminal responsibility to someone.
So the emphasis is really on the lack of a solid reason, a concrete basis, or a clear scope for the search.
Precisely. You see, it raises these fundamental fairness questions, doesn't it?
It really does. Why is that kind of broad, unfocused search seen as so problematic?
Well, think about due process. Instead of needing a reasonable suspicion before investigating, this flips it. You investigate first, hoping to find a reason.
Yeah, like throwing a massive fishing net out, hoping to catch any old fish without a specific fish in mind.
That's a perfect analogy. It hits exactly why it's problematic. It could easily lead to, trampling on fundamental rights, privacy, personal liberty, things like that. That's what Moraes da Rosa also points out.
Okay, so that's the fishing expedition forbidden. Now let's slip to the other side of the coin. Serendipitous findings, or encontro fortuito.
Right. This one sounds much more acceptable, legally speaking.
So what does this actually involve?
Well, in legal terms, serendipity here means unexpectedly discovering evidence of a crime that wasn't the original focus of the investigation.
Okay.
But, and this is the crucial part, this discovery has to happen during an investigation that was already legally authorized.
Ah, so the starting point has to be legitimate.
Exactly. If authorities are lawfully searching for, say, thing A, and they happen to stumble upon obvious evidence of crime B, that evidence can be considered admissible, under certain conditions, of course.
Okay, now this is where it gets really interesting, I think. How do the courts actually tell the difference between an illegal fishing trip and a lucky legal find?
It feels like a very fine line sometimes, doesn't it?
It really does.
And it is. The STJ wrestles with this constantly in its decisions. But the key factor, often it boils down to the legitimacy and the scope of that initial investigation.
Right. Was there a good legal reason for them to be there in the first place?
Exactly. And did they stay within the lines, the legally defined boundaries of that initial reason? Let's look at that first case you mentioned, HC 663.055, the house search. That might help illustrate it.
Okay, yeah, let's dive into that one. What happened there?
So in this situation, police officers went into someone's home. They said they were looking for a fugitive.
Okay. Chasing a fugitive seems legitimate on the surface.
Well, that was the issue the STJ pointed out. The legal basis for even entering was questionable. They didn't have a warrant, and it wasn't clear the situation met the strict rules for entering without one.
Ah, okay, so the entry itself was maybe shaky.
Potentially, yes. And while they were inside, they found drugs and a .32 caliber bullet. These were inside a cardboard box on a bedroom floor.
And the STJ's ruling, was that a serendipitous find because they were already inside?
No, they ruled the evidence was illegal. Minister Chieti specifically said finding drugs in a box wasn't just a mere chance encounter when you're supposedly looking for a person, a fugitive.
So rummaging in a box is different from spotting a fugitive hiding.
Exactly. The court felt the search went way beyond the initial justification, which was already maybe weak of just looking for a person. The discovery wasn't, immediately obvious or directly tied to finding a fugitive.
What really stands out to you about this one?
For me, it really underlines how, even if there's some initial reason to enter a private space, the actions inside can quickly turn into a fishing expedition if they wander too far from that original goal.
So you can't use looking for a person as an excuse to search everything.
Pretty much. Especially searching inside closed containers like a box. The link, the nexus between the reason for being there and what was found just wasn't strong enough. And finding drugs in a box doesn't suddenly make a questionable entry okay.
Got it. Okay, let's move to the second case. RHC 158.580. This involved a stop based on suspicious attitude.
Right, and this is something I think a lot of people might wonder about or have concerns over.
Yeah.
Police stops based on, well, a feeling.
So what were the facts here?
This case involved police searching a person and their vehicle. They didn't have a warrant. Their only justification was their subjective feeling that the person was acting suspiciously.
Just a hunch, basically.
Essentially, yeah. And during this search, they claimed they found drugs.
And how did the STJ react to suspicious attitude as a justification?
They were very clear. The search was illegal. Minister Chieti stressed that the founded suspicion, that's the term from Article 244 of the Code of Criminal Procedure for a lawful search, it must be based on objective facts.
Not just a vibe.
Exactly. It needs concrete signs that the person actually has illegal items, like drugs or weapons. A vague feeling of suspicious attitude. That's simply not enough. It can't be, as the minister put it, a salvo conduto for exploratory searches. A free pass, basically.
That's a really strong statement. So this connects to concerns people might have about, say, just walking down the street and being stopped because an officer thinks they look suspicious. That's not grounds for a search.
Precisely. This ruling reinforces a vital protection against arbitrary stops. Police need more than a gut feeling. They need actual demonstrable reasons to believe a crime is happening or illegal stuff is present.
Which helps prevent stops just becoming fishing trips for evidence.
Exactly. Protecting individual liberties there.
Okay, now let's switch gears a bit and turn our attention to this case involving a huge data seizure, RMS 62.562. This feels incredibly relevant today.
Absolutely. With so much of our lives digitized, these issues are huge.
What happened in this one?
It involved an investigation into possible corruption with the municipality's vehicle fleet management. And as part of that, the authorities ordered the complete copying of the entire database of the company managing the fleet.
Wow, the entire database. Was the company directly implicated?
That was the critical point, no. There was no initial evidence directly linking that specific company to the alleged fraud.
So they basically grabbed everything, hoping to find a connection later.
That's exactly how the STJ saw it. They ruled it was an illegal fishing expedition. The police even admitted they needed to analyze all the emails and data first, just to see if there was any link.
Oh, wow. So they admitted they were searching blindly.
Pretty much.
Yeah.
The STJ was clear. You need some initial indication of involvement before you conduct such a massive, invasive search. The suspicion has to come before the dragnet, not the other way around.
You can't just vacuum up terabytes of data and sift through it hoping for gold.
Exactly. It's concerning, right? When you think about the sheer volume of data we all generate, this case really makes you consider the boundaries of digital searches.
Definitely. It highlights the need for targeted investigations, even online. No digital dragnets allowed, essentially.
Precisely.
Okay, let's look at a contrasting case now. RHC 39.412. Here, the SCJ actually said the discovered evidence was legal. What made this one different?
This case involved a search warrant, a proper one, for a lawyer's office. The initial, specific, legitimate reason was to find a gun belonging to an intern working there.
Okay, so a valid warrant for a specific item.
Right. But while conducting that lawful search for the intern's gun, the police found a large amount of marijuana and another gun, this one belonging to the lawyer.
And the STJ said finding the drugs and the second gun was okay. Why was this different from, say, the drugs in the box case?
The crucial difference is the legitimacy and the clearly defined scope of that initial search. They were lawfully present because of the warrant for the intern's gun.
Right.
So when they came across obvious evidence of other crimes, the drugs, the lawyer's weapon, basically in plain sight during that valid search, the STJ said, well, you can't reasonably expect the police to just ignore that.
Ah, okay, so it fits the definition of serendipity perfectly.
Exactly. An unexpected discovery during a search that was legal from the start and had a specific target. It wasn't like they were just rummaging aimlessly. The other evidence was essentially right there while they were doing what the warrant allowed.
So, initial reason legal and specific, discovery incidental. Big difference.
That's the key takeaway from that one. If you're legally searching for X and stumble upon clear evidence of Y can be admissible.
Let's loop back to the digital world again with RHC 157.143. Accessing an attorney's cell phone data? This sounds tricky, bringing in privacy and professional privilege.
Very tricky. This case focused on lawyers suspected of coercing witnesses. A warrant was issued, allowing access to their cell phone data.
And the lawyers argued, what, fishing expedition in violation of privilege?
Yes, exactly. They argued both points.
How did the STJ handle that? It sounds like a real balancing act.
It was. The SCJ didn't really classify it as a pure fishing expedition or a simple serendipity. The key was that the suspicion was specifically aimed at these particular lawyers for these specific actions, the alleged witness coercion.
So it wasn't a random sweep.
No. And while the court absolutely acknowledged how important attorney-client privilege is, they ultimately decided that the necessity of the investigation in this specific context outweighed it.
But they still stressed protecting the privilege, right?
Right. Oh, absolutely. They emphasized that those handling the data had to be careful. They also tackled the practical issue. It's hard to just extract only relevant bits from a phone.
Yeah, technically difficult.
Right. So they acknowledged a full data copy, and later analysis might be needed, but crucially, any irrelevant data had to be returned afterwards.
So it really shows the complexities of applying these old principles to new tech, especially with sensitive info.
Definitely. Balancing investigation needs with fundamental rights in the digital age.
Okay, one last case study. CC 186.111. This one deals with serendipity and jurisdiction. Adds another layer, it sounds like.
It does. This came from a federal investigation into international drug and arms trafficking. During a search authorized by the federal court, they found illegal firearms in a suspect's possession.
Okay, standard enough so far.
But then the lower federal court tried to send the firearms charge off to the state court. They argued it was just a serendipitous finding, not clearly linked to the federal crime of international trafficking.
Ah, so they were saying this gun charge isn't our federal business.
Essentially, yes. But the STJ disagreed. They said the federal court did keep jurisdiction because of something called connexum processual, a procedural connection. Meaning, because the guns were found during a legitimate federal investigation into organized crime and arms trafficking, it was considered sufficiently connected to that bigger federal case. The initial search wasn't random. It was part of that specific federal inquiry.
So the context of the original investigation matters for jurisdiction too.
Absolutely. It reinforces that the legitimacy and scope of the initial investigation sets the stage for everything that follows, including which court handles related charges found along the way, if there's that logical connection.
Okay, so after looking at all these different scenarios, these cases,
Yeah.
what are the core principles? How do we really nail down the difference between a forbidden fishing expedition and a legal serendipitous find?
I think the core difference really boils down to this. A fishing expedition is essentially a blind, speculative search. You're hoping to uncover something, anything, potentially incriminating, without a solid starting point.
Just casting it about.
Right. Whereas serendipity is finding unexpected evidence, yes, but finding it during a search that was legitimate from the get-go, had a clear, lawful objective, and stayed within its legal boundaries.
And things like founded suspicion, beforehand, clear objectives, respecting warrant limits, those are crucial.
Absolutely crucial. Those are the guardrails that determine if evidence was obtained legally.
And for everyone listening, understanding these differences is really key, isn't it? For knowing your rights, for understanding how the system is supposed to work.
Precisely. The STJ is clearly grappling with this constantly, trying to shape that delicate balance between effective law enforcement and protecting individual liberties from unwarranted government intrusion.
So as we wrap up this deep dive, the big takeaway seems to be that the STJ is really actively navigating this tricky area,
Yeah, constantly refining the line.
trying to let law enforcement do its job, but also firmly protecting our rights against unreasonable searches. And the legality of evidence really hinges on that initial justification and whether the search stayed within bounds.
That's an excellent summary. And, it leads me to a final thought, maybe something provocative for listeners to consider.
Okay.
Given everything we've discussed, especially the digital cases, how do you think this massive digitalization of our lives is impacting these legal principles?
Does the sheer amount of data just make it harder?
Does it?
Sure.
Does it create new challenges in telling the difference between a legitimate, targeted search and a prohibited fishing expedition? I mean, what does all this mean for our digital privacy, really, and for the future of investigations?
That is definitely a lot to think about. Where do these principles go from here in the digital age?
Exactly. It's complex. It's evolving constantly. Staying informed is probably more critical than ever.
Absolutely. Well, if you are interested in digging even deeper, we definitely encourage you to look into the full rulings we touched on today. Thanks so much for joining us on this deep dive.